Hello, my name is Michael LeBeau. I'm a property tax attorney, and today we're going to talk about the parent-child exclusion and legal entities. But before I get started, I want you to remember something really important. This is a complex area of law. Before you take any of the steps I described today, it is really important that you engage me or some other competent property tax attorney to review what you plan to do. If you don't, and you make a mistake, you will be stuck with a property tax reassessment for as long as you own the property. This is the most important advice I can give you today. Please listen to it. Our first hypothetical involves a husband and wife with 2 children. Before this change in ownership planning, Main Street LLC holds real estate for the Smith family. The owners of Main Street LLC are John and Barbara Smith, who are husband and wife. After change in ownership planning, Dad is going to own 24.5%, Mom will own 24.5%, and each of the 2 children will own 25.5% of both Main Street LLC and the real estate. The approach I just outlined works whether you have 2 children or even more. It doesn't matter just as long as you have more than 1 child. This next hypothetical concerns one person who is unmarried but has 3 children. In this case, Main Street LLC holds real estate for the Smith family, and the owner of Main Street LLC is John Smith, a single man. After change in ownership planning, Dad owns 49.5% of the LLC, and each of his 3 children owns 16 2/3% of the LLC. In this case, when Dad passes away, the children would inherit their shares in the LLC without reassessment. Again, there are many steps to this process. Just transferring these LLC interests to your children could trigger a reassessment if you don't have effective help in this area. Our third hypothetical involves a husband and wife with 1 child. Before change in ownership planning, Main Street LLC holds real estate for the Smith family. The owners of Main Street LLC are John and Barbara Smith, husband and wife. After change in ownership planning, Dad will own 24.5% of the LLC, Mom will own 24.5% of the LLC, and their child will own 51% of the LLC. Here, when one parent dies, the other would obtain the deceased share's interests. But because of careful planning, when the last parent passes away, that child will inherit all of the real property owned by the LLC without reassessment. It took many steps to reach this point. If you make these transfers without planning and without advice, you could trigger a reassessment. This same approach works whether you're married with 1 child or unmarried with 1 child. So long as the child has 51% of the LLC when the last parent to die passes away, then you can avoid reassessment if you planned effectively. Before this change in ownership planning, Main Street LLC holds real estate for the Smith family and the Jones family. The owners of Main Street LLC are John and Barbara Smith as to 50%, and Cliff and Melissa Jones as to 50%. After change in ownership planning, each dad would own 12.5%, each mom would own 12.5%, and each of the children would own 6.25%. As each parent dies, the surviving spouse would inherit the deceased spouse's share. As each parent passes away, the surviving spouse would inherit the deceased spouse's interests. Through effective planning, we can avoid the change in ownership reassessment that'll occur when the 3rd spouse passes away. There are many steps to this process, and just transferring LLC interests to your children could trigger reassessment unless you planned effectively. One of the most frequently asked questions we receive in regards to this change in ownership planning is in regards to mortgage loans. Will your lender allow you to engage into this type of planning? And the answer is sometimes. This type of planning can trigger what's known as a due on sale clause. But if you go to your lender and ask for permission, they will allow you to do this in many cases. Another frequently asked question arises in regards to LLC income distributions. Do I have to give my child an income distribution during their lifetime? And the answer is not necessarily. In this situation, you can ask your attorney to draft the LLC agreement in such a way that it will accumulate the income in lieu of distributing it. Another frequently asked question concerns your children. Do you have to leave an interest to every one of your children? And the answer is no, you don't. But it requires careful planning. Again, this is one of those situations that if you make a mistake, you can cause a reassessment. The last frequently asked question in this presentation concerns business partners. What do I do if my business partner doesn't have children? The answer is simple, but it does require advanced planning on your part, and we can still make it work. When dealing with the parent-child exclusion, there's some important rules to remember, especially in regards to your family trust. If your family trust creates the ability to sprinkle or spray income or principal to any of the beneficiaries, then you might have a problem. That problem arises in the context of how you identify those beneficiaries. If you identify the beneficiaries as children, you're okay. If you identify them as issue or as descendants, that could cause the parent-child exclusion to fail and have all of the property in the trust subject to reassessment. The parent-child exclusion can encounter problems in trusts and in life estates. If you create a life estate for the benefit of a grandchild, you have just lost the parent-child exclusion if your children are still alive. In the context of a trust, if you leave a trust life estate that provides income to a grandchild while your children are still alive, it can cause a reassessment.